welcome everyone who has joined us in person or those joining us by live stream. This evening we have two presentations. First, we have the Vice President of the Queensland Law Society, Rebecca Fogarty, who will provide a brief introduction to the new Queensland Law Society Supreme Court Library exhibition, A Force for Good, Past, Present and Future, Your Law Library and the QLS celebrate 150 years since the foundation of Queensland's first Law Society. And secondly, the Selden Lecture by Helen Gregory, the Queensland Law Society serving conscientious, honest lawyers. When I was approached to introduce the speakers this evening, I realised I was perhaps uniquely, properly qualified to do so. I was a long-standing member of the Queensland Law Society as a practising solicitor and received my 25-year PIN in 2019. I was a member and Deputy Chair of the Litigation Rules Committee of the Queensland Law Society for a number of years. Since my appointment to the court, I was made an honorary life member of the Queensland Law Society in 2021, and I am currently Chair of the Supreme Court Library Collections Subcommittee. The abstract for tonight's Selden Lecture states, a statement praising conscientious, honest lawyers was published in a Brisbane newspaper in 1874. At that time, the public image of lawyers, barristers as well as solicitors, was poor. For decades, Queensland Parliaments were inclined to agree. The creation of the Incorporated Law Society was seen as an important step in improving the reputation of lawyers. In order to understand the creation of the modern Queensland Law Society, it is necessary to understand the challenges which needed it to be addressed, how government was persuaded to pass the necessary legislation against the background of the expectations of solicitors, the Parliament and the public. The Queensland Law Society Inc. was created and has developed in the enveloping context of the nature of Queensland and the place of professionalism within that context. Given my involvement with the Queensland Law Society over the years, I realise I have a vested interest in this topic. I keenly await to hear Ms Gregory's ultimate conclusion. Now, before I hand over to Rebecca Fogarty for her introductory remarks, it is appropriate for me to say a few introductory words about Ms Fogarty. Rebecca is a Queensland Law Society accredited specialist in criminal law and a partner at Jasper Fogarty Lawyers, specialising in criminal defence and domestic violence law. Since 2019, she's been Chair of the Queensland Law Society Criminal Law Committee and previously held the position of Deputy Chair. She sat on the Queensland Law Society's Specialist Accreditation Criminal Law Committee in 2018 and 2020 and was also the Queensland member of the Professional Standards Councils. She has been recognised as a leading criminal lawyer in the Doyle's Guide at both a state and a national level. Outside of the courtroom, she has published articles across a range of formats, including the Caxton Online and Proctor, and regularly speaks on topics of interest to the profession. In addition to issues within the criminal law and domestic violence space, Rebecca is particularly interested in risk and compliance as it impacts the profession, maintaining and promoting professional standards, and developing beneficial relationships with non-legal stakeholders. On that note, I'll hand over to the Vice President of the Queensland Law Society, Ms Rebecca Fogarty.
Thank you, Justice Williams. I acknowledge the Turrbal and Yagara nations on whose lands we gathered this evening. I also acknowledge the Honourable Chief Justice, distinguished guests, colleagues and friends. I thank the Selden Society and Justice Bradley, Chair of the Supreme Court Library Queensland's Legal History Committee. It is an honour to be here tonight to open the new Queensland Law Society and Supreme Court Library exhibition, celebrating 150 years since the foundation of Queensland's first Law Society. I extend my sincere thanks to the Supreme Court Library for providing us with this unique opportunity to commemorate our sesquicentennial. This has been a truly collaborative effort, and the result is a genuinely insightful journey through 150 years of our legal profession. Now, the exhibition includes artefacts from the earliest days of the Society, including the first book of minutes from the Society's inception, And I do hope that this evening will incite your curiosity to perhaps wander up to level 12 and visit the exhibition. From just 15 solicitors in 1873, the Society has grown to represent more than 11,000 members. It regulates more than 14,000 solicitors in Queensland. As Justice Williams noted, the Society was established from a sincere desire on the part of solicitors to protect the public from those, unfortunately, within its ranks who were guilty of dishonourable conduct, and to safeguard the reputation of the profession. Its founding vision was to be a force for good, to support good lawyers, to advocate for good law, and to serve the public good, a vital part of our system. Turning these goals into reality required more than just vision. It required an incorporated society with the authority to be master of its own house. Tonight's lecture focuses on the challenges which needed to be overcome to achieve this legislative breakthrough. Now, 150 years later, in truth, there is much good that the profession and its society has done to fulfil its original mission. We created the Fidelity Guarantee Fund to protect the public, and we brought this innovation to the Commonwealth and to New Zealand. In World War II, we sought changes to the formalities for making wills, so as to enable World War II servicemen to make verbal and battlefield wills, and to enable minors under the age of 21 who were serving to make a will. In the 1960s, we created a new legal assistance scheme for civil law matters, which uniquely was funded entirely on the interest on solicitors' trust accounts. We were one of the first movers in Australia to create a compulsory professional indemnity scheme for its members. That was in the 1970s. And in the early 2000s, we moved to protect speculative personal injury clients by capping professional fees to ensure that injury compensation schemes would remain fair and sustainable. Perhaps more difficult to quantify, but no less importantly, a strong law society, like a museum or an art gallery, it enriches the professional culture of its members and enriches the intellectual and moral dimensions of practice which bind us. Presenting tonight's lecture is historian Helen Gregory. Helen has published many commissioned histories, including a history of the Queensland Law Society, a history of the Brisbane River, and a history of Brisbane's martyr hospitals. She has written historical backgrounds for major museum exhibitions. She taught at the University of Queensland and was an adjunct professor in the Department of History. She has also been a Director Cultural Heritage in the Queensland Environmental Protection Agency and has broadcast on history topics for ABC Queensland. Please join me in welcoming Helen to the stage.
Your Honours, ladies and gentlemen, and people in Streamland, I'm honoured to speak about the history of the Queensland Law Society in this very special sesquicentenary year. As an historian in this distinguished company in the august setting of the Banco Court, I take great comfort in knowing that John Selden's first publications were in history. The modern Law Society is a direct descendant of the first Queensland Law Society, formed on the 8th of August 1873 with a very ambitious brief. Its objectives run with some fluctuations in emphasis from 1873 to this year. These objectives introduce the themes of this paper and can be summarised as promoting ethical practice, dealing with dishonourable conduct, advocating for the profession, encouraging continuing education and contributing to law reform. On the 8th of October 1874, the Brisbane Courier declared, "A conscientious, honest lawyer is one of the best friends and safest protections one can have, against oneself just as against one's enemies." Almost 150 years later, such a statement could be regarded as ideal PR for the profession. But what is a conscientious, honest lawyer? As a former Chief Justice, the Honourable Paul de Jersey AC expressed it, the essence of the profession is the very best service of the people. Duty, responsibility, integrity, knowledge, autonomy are all qualities implicit in the concept of professionalism. A comprehensive statement on the modern Queensland Law Society website expresses ideas similar to the 1873 Society's purposes. QLS empowers good lawyers, advocates for good law, and serves the public good by providing a clear and passionate voice for solicitors and the legal profession in Queensland. We engage with government, the public, and the legal community on issues of importance to the profession. This contemporary statement puts good lawyers and the public good at the centre of the Law Society's mission. The Society, however, has always been required to address three constituencies: the profession, the public, and the government. At various times, the public and the government have been constituencies at least as influential as the profession. This tripartite mission was not particularly obvious when the bill to create the Incorporated Society was introduced on the 25th of October 1927. The Attorney-General, John Mullen, invited the House to consider the desirableness of introducing a bill to provide for the incorporation of the Queensland Law Society to make further provision for regulating the legal profession in Queensland. The only purpose specifically stated in this invitation was regulating the legal profession. The Daily Standard, ever watchful of the public interest, stated boldly that the attorney's preeminent aim was to keep the profession clean. Other headlines were even more blunt. "Black sheep among legal men" was one, with a subheading, "Drastic power for Law Society." The drastic power resided in the Statutory Committee, which could suspend a member or strike an errant solicitor off the roll. The deputy leader of the opposition, a prominent solicitor, Reginald MacDonald King, successfully advocated for a clause to ban unqualified people from holding themselves out to be solicitors, an amendment labelled in the press as "dealing with legal quacks." It would be too easy to categorise lurid headlines simply as examples of the press's penchant for prurient stories. Calls for reform and punishment go far deeper than that, far further back than October 1927, and much further forward in the subsequent 96 years. The modern society and its antecedents have developed within the enveloping context. First, Queensland's decentralisation. Queensland is enormous, yet the centre of political, economic and legal power resides in the extreme southeast. Settlement away from the coast has always been sparse, challenging efforts to provide infrastructure of any kind, including legal services. Queensland's size contributed to the development of intense regional loyalties, strong regional capital cities, and tensions between regional Queensland and Brisbane. The second context, the reaction of governments to public pressures and public perceptions of the legal profession and legal procedure. Sometimes government has been very intrusive. At other times, the society has had the ear of government, but often apparently not. The third context, the development of the concept of professionalism and the growth of professional organisations in the 19th and 20th centuries. Government and the public have high expectations of professional organisations. Discussion and dissent on managing and regulating the solicitors' branch of the profession is almost as old as Queensland. During the 1860s, Queensland's first decade, there was persistent criticism that some solicitors were either negligent or fraudulent, charged excessive fees, and that legal procedures were far too complex. The Supreme Court was firmly in charge of legal practice. Provision for the creation of examination boards and the admission of 3 categories of lawyers, barristers, solicitors and conveyancers, were set out in the Supreme Court Constitution Amendment Act 1861. Section 41 of the Queensland Supreme Court Act 1867 excluded unqualified people from engaging in conveyancing or any procedure for use in court. The passage of the Costs Act 1867 did not quiet complaints that legal services were too expensive. The recreation of the First District Court did not vanquish complaints from North Queensland about the need to travel to Brisbane for the trial of complex cases. The complexity of legal procedures and costs were regularly criticised in the 1860s and in Parliament, and they were cited in evidence to the 1869 Select Committee on the Administration of Justice in the Superior Courts. Several legal practitioners' bills were presented unsuccessfully to Parliament in 1869 and the 1870s, and they aimed to fulfil government aims to construct a simpler, less expensive system. The legal practitioners' bills gave solicitors unlimited rights of appearance in the courts, thought to reduce procedural complexity and cost, reflecting the difficulty experienced by litigants in the country in finding competent barristers to appear for them. The Bar and some solicitors in Brisbane opposed this effective amalgamation. Even the 1874 amendment of the Supreme Court Act to enhance solicitors' rights of appearance failed to discourage the proponents of amalgamation. Eventually, the Legal Practitioners Bill 1881 was passed, but very few lawyers took advantage of amalgamation. Charles Lilly, at various times Attorney General, Premier and Leader of the Opposition before his elevation to the bench, was interested in law reform. Lilly opposed the Legal Practitioners Bill 1871, mainly on the grounds that it did not provide sufficiently for the education of the profession. He swung behind the concept of amalgamation in the Legal Practitioners Bill 1872. He pointed out that the conditions in the colony had effectively amalgamated the profession, as solicitors were regularly appearing in the courts. He acerbically pointed out that physicians frequently practiced as surgeons and vice versa without attracting any acrimony. Events during the 1870s are pertinent both in analysing the pressure to create the incorporated society and identifying the issues it aimed to resolve or promote. Even the comparatively recent Legal Profession Acts 2004 and 2007 reflect much older ideas and pressures. The decade of the 1870s was significant. The Queensland economy was improving, settlements spread, calls on government to provide transport infrastructure were louder, social infrastructure such as legal and medical services lagged. Lilly's speech in the debate on the 1872 bill revealed his concept of an ideal professional organisation. The profession, he said, should be incorporated into a society which would have great control over the members and compel them to respectable modes of practice and in other ways generally to control the morale and discipline of the profession. He proposed an amendment to give the profession power to regulate and govern itself. Although the Legal Practitioners Bill 1872 failed, a shadow of Lilly's concept emerged in the formation of the first Law Society in August 1873. It operated against the background of poor public image and mounting demands of some solicitors to protect their rights and their practices against the incursion of unqualified people. The formation of the society was warmly welcomed in the press, who regarded it as an attempt to remove the odium attached to solicitors by eliminating the black sheep from the profession who had given solicitors a questionable character in the public eye. A professional organisation dealing with members who engaged in any form of malpractice would seem to be an important step in developing a well-functioning civil society. However, the size of Queensland intruded. The Law Society's membership, never large, only 27 in 1874, its second year, was dominated by well-established urban partnerships. Distance to Brisbane, aggravated by poor communication, put the society beyond the reach of most country solicitors. The encroachment of illegal conveyancing was particularly common in regional areas in the 1870s, when transactions in land grew in response to the improving economy. Reputation and conduct were at the forefront of deliberations of the Law Society. At its first annual meeting in 1874, the President, Robert Little, reported that the Society's Council had directed its efforts prominently to the suppression of dishonourable practice. The Council was hopeful that this would strengthen the Society. However, any chance of stronger efforts was limited by both unwillingness of people to report incidents of unqualified practice and by the low number of members. Queensland was not alone in creating a solicitors' organisation. In England, the London Law Institute, the forerunner of the Law Society of England and Wales, was founded in 1823. In 1842, New South Wales solicitors got together, and in March 1859, the Law Institute of Victoria was formed. Solicitors were not alone in creating professional organisations. Many of their issues were shared. The aims of early law societies can also be found in the history of the Australian Medical Association. In 1871, a Queensland Medical Society was formed, but like the first Queensland Law Society, faded through insufficient support. In 1882, the doctors tried again. The third attempt in 1886 was more successful. Almost immediately, that society tried to influence governments on issues ranging from controlling alcoholism to registering nurses. However, the early medical societies came to grief over ethical questions familiar to the law societies: advertising, fees associated with unregistered persons. The Medical Association also felt the pressure from regional strength, and eventually the Queensland two medical societies merged with the BMA to create the British Medical Association Queensland branch in 1900. Although the Law Society aimed to protect its members against competition from the unqualified and the public from malpractice, it had no power beyond encouraging self-regulation through persuasion and peer pressure. Kindred societies in the other colonies were similar. Prosecution of those who strayed was costly, and in any case the Supreme Courts retained all power over both discipline and admission. Lack of resources to mount prosecutions led to increasing requests that the solicitors themselves investigate the misconduct of others. The issue of unqualified conveyancers, especially real estate agents and bank officers, was something of a dilemma for the early Law Society. It seems that Parliament was only too ready to abide with the public, leading to fears that the government might allow such conveyancing. So fear of possible government action became an enduring theme in society history. The first Queensland Law Society couldn't defend their profession, but the idea that solicitors needed an effective organisation reappeared in the creation of the Queensland Law Association in 1883, when the Queensland economy was beginning to boom. But there were downsides to prosperity. The gap between rural areas and the larger towns and cities widened. Larger forces were also at work. The louder voices of a vigorous middle class and the growth of consciousness among workers of their role in creating affluence increased pressure from the general public, which was becoming better educated and increasingly sceptical. In the era of laissez-faire in trade, why shouldn't the professions be as open? Public attacks on the professions, essentially the doctors and the lawyers, became more vocal. After the passage of the Legal Practitioners Act in 1881, the newspapers, sceptical that amalgamation would reduce costs again entered the fray, suggesting that solicitors were acting after the fashion of a trades union. The rise of trade union attacks on privilege of any kind highlighted the power of ordinary people acting in concert. Advocacy for cheap law increased, but by 1891, the Law Association, having failed to create significant members, could not effectively defend them. The association was impotent when allegations of negligence emerged. Complainants were informed to seek a civil remedy. The election of the Ryan Labor government in 1915 challenged the Law Association and the profession on several fronts. This was a government which aimed to place government at the centre of Queensland life. The growing strength of the trade union movement was a formidable power base for government action. The Ryan government aimed to organise everything from primary produce marketing to legal practice. The writing was on the wall for challenges to traditional practice when the creation of the State Government Insurance Office removed workers' compensation from court proceedings. The establishment of the Public Curator's Office placed the government as a competitor to solicitors and conveyancers' administration of wills and estates and transactions in land. The clerks' union's move to bring article clerks under the Clerks Award brought unionism to the office door, a matter of special concern to the country practitioners who could ill afford higher salaries. Tensions between solicitors and the government eased during the 1920s. The Law Association was relieved that its advocacy had deterred the government from abandoning the ban on practice by the unqualified. Fortunately, the Crown Solicitor and the Registrar of Titles favoured the retention of the ban, not because they wished to protect traditional practice, but because solicitors were more easy to sue for negligence. There was an encouraging spark on one front. The QLA, Queensland Law Association, completed a scale of fees for conveyancing in 1925. Even though the government didn't apply the scale at the Public Curator's Office, the advent of this scale coincided with an improvement in the profession's relationship with government. The association president, R.J. McNabb, supported Premier McCormack's action in vanquishing the 1927 railway strike, likely a key expression of the careful diplomacy practised by the Law Association in the 1920s. In view of earlier Labor government's apparent hostility to the profession, it is perhaps surprising that in January 1927, the Law Association was able to commission the Acting Parliamentary Council to draft a bill to incorporate the society, as Charles Lilly had advocated in 1872. But Queensland was late in this field. The Law Society of England was incorporated in 1837, New South Wales in 1884, and Victoria in 1917. It is even more surprising that the draft bill, which echoed the Law Institute of Victoria legislation, had a relatively peaceful passage through Cabinet, which even yielded its earlier stance that conveyancing by unqualified people should be allowed. Cabinet would not agree, however, that the society could mimic the trade unions with compulsory membership. John Mullen, the Attorney-General who introduced the legislation, was not a lawyer, but he was known to have an extensive legal library. His second reading speech passed almost without challenge from the opposition. R.M. King's amendment proposal included the observation that the acts regulating doctors and land surveyors specifically excluded unqualified people. The government accepted the amendment. King had pointed out that it protected the public as much as the profession. The attorney's closing remarks that the great majority of solicitors observed a decent code of honour, let down by a few who brought the profession into disrepute, were greeted with "hear, hear" from the only practising solicitor in the House, R.M. King. Mullen also referred to the salutary effect of another regulatory measure, the Trust Accounts Act 1923, which he regarded as of incalculable benefit in reducing defalcations through a tight regime for managing trust accounts. The Law Society Act created a professional organisation with real teeth, governed by a council of no fewer than 8, or more than 11. The government kept a foot in the door with a representative of the minister on the council. Only those with certificates issued by the society could practice. The Act included powers to investigate complaints and to discipline those found wanting. The 5 members of the statutory committee were nominated by the council and appointed by the governor in council. The statutory committee could receive complaints referred by the society's council if, after investigation, they were of sufficient importance. That reservation had consequences decades later. The minister's power to refer complaints to the committee implied a degree of government oversight, a situation which also recurred. The powers of the statutory committee were considerable, but it was not a statutory committee which could do what it liked. Rules of court regulated its practice and proceedings. The Act was proclaimed on the 2nd of April 1928. It was a smooth transition. Effectively, the Council of the Law Association became the Council of the Queensland Law Society, albeit with a representative of the minister. Neville Henderson remained as secretary, operating from the Society's first office, his desk in the offices of Henderson and Lay. The Society governed a growing profession. 240 solicitors in 1916 had increased to 346 in 1926. The Law Society Act was not the only measure designed to regulate a profession. In Queensland by 1929, doctors, dentists, pharmacists, surveyors, nurses, optometrists, auctioneers, real estate agents and architects had all been regulated. Nor was this urge to regulate confined to Labor governments. The Professional Engineers Act 1929 is pertinent. The Moore government had replaced the Labor government in May 1929. R.M. King became Deputy Premier and Minister for Public Instruction and Public Works. In his second reading speech on the Engineers Bill, King repeated some of the factors familiar from the Law Society Bill. Regarding the Engineers Bill, King emphasised that the protection and safety of the public were the key issues in any professional regulation. In the debate on the Engineers Bill, 2 future Labor premiers, Frank Arthur Cooper and William Forgan Smith, foreshadowed an issue which exercised the legal profession in future decades: uniformity of registration and regulation among the states. Very early for that idea. Cooper also raised issues which linked the earliest law society to the modern society: standards of education and whether or not professions with power under their own acts could or would act primarily in the interests of their members by, for example, setting fees or restricting entry to the profession, thus becoming closed corporations. Whether or not the Law Society was closed, it certainly covered a widely spread profession. In 1931, for instance, about half of the 363 members, 151 solicitors and 32 conveyancers practised in Brisbane. There were 14 solicitors in Rockhampton, 9 in Townsville, and 157 and 1 conveyancer in various country towns. The Society had already embarked on the most significant of its early initiatives: enhanced protection for the public through the Fidelity Guarantee Fund. The Society was accused of dragging its heels and dealing with widely publicised defalcations. Justice Hugh McCrossan was reported as saying that both the Council and the Statutory Committee had ignored their duty to the public, generating a dreaded headline: "Failed in duty." The President of the Society responded, pointing out that no complaints about defalcation had been received, but the Society had already taken action regarding other charges against the same solicitor. The judge referred the issue to the Attorney General. The Society had actually suggested a way forward in January 1930, 2 months before the McCrossan judgment. A subcommittee had examined New Zealand's Fidelity Guarantee Fund Act, passed in 1929. The Law Society made a public statement a few days later, recognising that it did have a duty to protect the public against exploitation. There was unease within the Society. The chairman of the Statutory Committee, E.H. McCartney, resigned on his appointment as Agent General for Queensland. Macartney expressed his view that the legislation by which the committee has been constituted has been perhaps a little premature for Queensland. In a small community where members of the profession are more or less generally known, the one to the other, and in so many instances are associated not only in business transactions, but in many instances by closer ties, the objection to this large jurisdiction seems to me to be a substantial one. By June 1930, the Society was ready to present its plan for a fidelity fund to the Attorney-General, N.F. McGrawty. The press changed its tune. Citing the Queensland Magistrate, the Week said, "The community will welcome any proposal that will give security from the rascality of solicitors. As a quid pro quo, the community should take care that the solicitors are treated fairly. In Queensland, the profession has been treated harshly for years. The profession has died down to a scale of fees that is absurd. A community that desires honesty among solicitors should see that the solicitors are given a chance to live." Attorney-General McGrawty informed Parliament that the bill was a purely voluntary effort by the legal profession and showed that solicitors were prepared to tax themselves to protect the public. His outline of the bill was more comprehensive than usual in introducing legislation because he didn't think a long second reading speech would be necessary. John Mullen, then the Shadow Attorney-General, considered that the fund was a step in the right direction. Solicitors on the government side of the House said the fund would increase public confidence. The bill passed in one day. New South Wales and Victoria followed. None of the 356 solicitors in Queensland could receive a practising certificate until their annual contribution to the fund was paid. Compensation was limited at first, but gradually increased. Claimants could only be reimbursed for the balance of their loss after they'd secured any remaining funds from the defaulting solicitor. The legislation allowed Council to appoint an accountant to audit any solicitor's trust account. The Auditor-General audited the fund. In 1952, the Act was amended to allow the Society to claim damages from auditors who did not pick up irregularities in trust accounts. But the inauguration of the fund couldn't have come at a more difficult time, the advent of the Great Depression. Solicitors' fees were reduced and many struggled to pay their contributions to the fund in full and on time. In 1931, the Society found a way to transmit its policies and activities to its members. It had its own pages in the Journal of the Law Institute of Victoria. Some Queensland contact attracted wider attention. G.R.H. Gill's address on ethics was printed in the journal and covered in the press. Gill's message was clear. To honesty, a lawyer must add honour. Courage must be tempered with discretion and industry controlled and directed with care. Education in ethics was regarded as an essential step in preventing malpractice and misconduct. The Ethics Committee was appointed in 1944 and published its rulings in the journal. Beryl Donkin, appointed to assist Neville Henderson in 1941, maintained a register of rulings scrupulously. In 1946, ethics became a subject for examination, but Article Clerk instruction in ethics depended mainly on the master. The publication of Professor Harrison's Law and Conduct of the Legal Profession in Queensland reinforced the ethics emphasis. Attracting and maintaining public confidence in the profession was always a central preoccupation. Working in and with the community was another way of addressing the difficult issue of public confidence. During the Second World War, as we've heard, solicitors prepared soldiers' wills free of charge and assisted their dependents. Wartime legal aid continued after the war, but this was not sufficient in the Society's eyes. The President, T.J. Bale, emphasised that this activity and acting pro bono for charities was insufficient. The state, however, had been active. Since 1915, the public defender had been available for those charged with criminal offences. In many parts of the world after the Second World War, broader financial assistance was developed. In Britain, legal aid was a cornerstone of the welfare state. The Law Society couldn't avoid the issue. It hoped, however, to control the provision of legal aid and criticised the government for its lethargy in devising a scheme. Such criticism was, however, rather muted. There were fewer lawyers in Parliament in the mid-20th century than in the 19th century, yet the Law Society needed more voices in the corridors of power. Persuading the banks to pay interest on the considerable sums they held in solicitors' trust accounts was a promising avenue for legal aid funding. The Liberal Country Party Coalition Attorney-General, Dr. Peter Delamoth, was open to this idea. Some solicitors, however, believed that any interest paid on the trust account should go to the relevant client. The Society suggested that 50% of the interest on the lowest balances in trust accounts could go to the Fidelity Guarantee Fund, a further 30% could go to legal aid, and the remaining 20% to the Society for its own purposes. Dr. Delamoth resisted the diversion of any interest to the Society's administration. The 1960s were not good years for the fund, and for the first time since 1930, practitioners were called upon to increase their contributions. The Society's moral position was strengthened by the 1962 amendments to the Act to authorise compulsory audits on trust accounts. It was a larger profession in the 1950s, but rising overheads rubbed against the after effects of wartime control on scales of fees. The Society believed that it should control legal aid to preserve solicitor-client relationships. The Legal Aid Bill 1965 was introduced to Parliament in December. Reminiscent of 19th century attitudes, some members criticised the Society. Ned Hanlon, a future Premier, for instance, claimed that the Society's processes were dead slow or stopped. However, the scheme was inaugurated in February 1966 without government funding. Queensland was a leader in legal aid, but after the Whitlam government introduced the Australian Legal Aid Office, it was amalgamated with the Queensland scheme. The Society was active in legal assistance on another front. The Community Lawyers Scheme began in 1979. Volunteer solicitors made themselves available to advise clients at storefront legal offices. They were not permitted to refer clients to their own firms. The Society regarded this scheme as bringing the law closer to the public to reduce enduring criticism that the law was a closed shop shrouded in mystery. The Women's Legal Service joined the Caxton Street Service and one in Inala. However, resources were always very tight. In 1977, the fixed fee consultation scheme, supported by 85% of the profession, was introduced. By the 1970s, it was generally a better educated profession. Improving solicitor standards of education had been a consistent theme since the 1860s, yet Queensland had lagged in the provision of tertiary education in law. The first university law course was introduced in 1935. In 1961, A.G. Lavers became the first member of the Law Society Council with a degree. Queensland degree. Although the post-war Commonwealth Scholarship Scheme improved access to universities, many young people in country and regional areas could not afford legal study in Brisbane and therefore relied on admission on the completion of 5 years in articles. The concept that article clerks were apprentices being educated, as were, for instance, nurse trainees, helped to dilute pressure towards the unionisation of article clerks. For some years, the University of Queensland ran a course for article clerks, both those article for 5 years and graduates article for 3. The tenor of the times brought changes. Masters were simultaneously employers, teachers and managers of practices, and the education of clerks could suffer. Larger firms were developing specialties, which limited opportunities for broad training. In 1972, Tasmania introduced a 1-year tertiary practical training course. The Queensland Institute of Technology's first course in 1976 became the legal practice course. It seemed that universities were taking over legal training. Improved educational opportunity produced a large growth in the profession. The demography of the profession was changing towards dominance by younger practitioners, women as well as men. Public relations efforts could no longer be confined to improving the profession's image. Effort needed to be directed towards building bridges between established and newly admitted solicitors, between new firms and long-established ones, between the South East and the North and West, and particularly between the society and its members. The perception lingered that the Law Society was essentially a Queen Street body in a highly decentralised jurisdiction. Tension between Brisbane and the region was evident in many spheres of Queensland life. Solicitors in the regions pressed for representation on council. In 1951, the 19th Century Downs Law Association was revived, and an association was formed in Townsville in 1959, followed by one in Rockhampton. In 1960, the Council of the Society copied the British Medical Association in arranging convocations with District Association. The regional associations presented the Society with a variety of issues, including concern that the Society was run by and for the big metropolitan firms and that the public image of the profession was poor. The Downs Association wanted a lawyer to be appointed to the Society's staff, an idea found too expensive until Scott Carter was appointed in 1976. The development of more and more interest groups and the advent of suburban practices presented a management challenge to an organisation anxious to ensure that interest groups did not threaten cohesion. Regional membership of council was a hurdle. It was difficult for regional solicitors to attend meetings. Instead of sectional representation, the council encouraged regional members to contest elections. By 1970, about 40% of the membership was aged under 36. The Young Members Committee became particularly vigorous, protesting that the Society was an old Queen Street body, advocated by-election for council vacancies so that the old order didn't keep perpetuating itself, which was added to by the fact that many former council members became members of the Statutory Committee. And in 1974, the Act was amended to establish by-elections. The young members also began continuing legal education, the first glimmer of which had appeared in the 1920s when ACV Melbourne, Professor of History at the University of Queensland, was commissioned to deliver a series of lectures on constitutional law. The first modern CLE seminar at Caloundra in 1961 was followed by educational and social weekends at Lennon's Broadbeach, the Chevron at Surfers Paradise, and the Casino Hotel at Broadbeach. The first full-time director of CLE was appointed in 1979. The gender demography was also changing. The Women's Lawyers Association, formed in 1978, was different from the other interest groups. It included barristers and academics and liaised more closely with other professional groups. Carmel McDonald's article in the Queensland Law Journal claimed discrimination against women solicitors, particularly those working in the big firms. The rules on advertising were gradually changed. Rulings on advertising had been the business of the Ethics Committee. Prohibition gradually relaxed. Discrete business cards were permitted in 1981, newspaper advertising in 1988, incorporation of practices was allowed in 1990s. Large partnerships with links or mergers with interstate practices became more common. Practice management was increasingly emphasised. In supporting the profession, the Society was, in some eyes, taking on the appearance of a trade union. However, after the war, the higher educational standard common among solicitors was mimicked by the rising standard of education in the general community. By the 1960s, the Society was under pressure to promote the profession to the public. The profession is, after all, a service industry dependent on public demand. The increasingly diverse membership also increased the pressure on the Society to promote itself to the profession, but public relations was never an easy task. See a Solicitor First became the theme of a public relations campaign in the 1980s. Law Day, inaugurated in 1981, was extended to Law Week. Some solicitors became visible watchdogs of the rule of law in the community and upholders of the Westminster system. They expressed that in the 1970s and 80s with increased activity in civil liberty movements, which often criticised Queensland government attitudes and actions. The Society's reluctance to be too critical revealed that the shadow of possible government takeover of regulation remained. Other shadows emerged more clearly. The Society's relationship with the Liberal Country Party Attorney General Delamov was productive, but did not extend to others in the coalition government. William Knox, Attorney General, at one stage favoured amalgamation, and in one debate, Knox said that he was concerned about slowness when complaints were made. And there were new challenges to traditional practice. The do-it-yourself movement for divorce, wills and conveyancing was particularly difficult for country solicitors. The public trustee, successor to the public curator, continued to be an active competitor. Defalcations punctuated the troubled financial climate of the 1970s. The growth of the profession, doubling in the 1970s and doubling again in the 1980s, was a challenge. The public tended not to discriminate between negligence and dishonesty. Litigation against solicitors increased with the rise of consumer consciousness, which coincided in the 70s with booms and busts in the economy. Indemnity had first been mentioned in 1949, but in the 1970s there was a move among all state societies to see if they could amalgamate to form a scheme to have a better negotiating position with insurers. Voluntary PI schemes in New South Wales and Victoria were not successful. The advent of the compulsory PI scheme in Queensland introduced law claims to the Society's headquarters. Law Claims section ran education programs to prevent claims. The opening of the Department of Professional Conduct in 1984 demonstrated that prevention was becoming a larger and more overt society activity. The composition of the council also changed. In 1964, the conveyancer representative was replaced by a solicitor. In 1966, the council increased to 12 members. D.A. Suthers became the first North Queensland councillor. The larger metropolitan firms did, however, remain dominant on council, difficult for sole practitioners or small firms to give the required time for council membership. Women on council continued to be a rarity. Elizabeth Nosworthy became the first woman president in 1986. The growing range of society activity created a need for a larger staff. Administration began with one person in 1928, Neville Henderson. Beryl Donkin, as the older practitioners would remember, she who was always obeyed, arrived as Assistant Secretary in 1941 and succeeded Neville Henderson in 1984. She was the only woman to be a Law Society Secretary in the British Commonwealth. She retired in 1981 after 40 years. A more complex society needed larger premises. After almost 40 years in various parts of the National Mutual Building, a move to Qantas House and then to 1996 Albert Street, when for the first time the name Law Society House was used, at last, in October 1987, the Society moved into its own building. The design brief for Law Society House was straightforward. The building is to be designed for a minimum 20-year period of occupation. A quality, durable and flexible layout is therefore required. That design brief could almost be seen as a design brief for a modern law society. Quality, durable, flexible. The Society's move to its new house coincided the beginning of changes which whirled ever faster in ensuing years. In some ways, the QLS trod its own path. In others, it became part of broader national movements. In 1985, the year when the Office of Legal Ombudsman was created, the Societies Act was amended, and these amendments are significant. They were harbingers of things to come. The government's creation of the Solicitors Disciplinary Tribunal was, as the Attorney-General expressed it in his submission to Cabinet, a response to experience which has shown that the use of the statutory committee and the powers it possesses has created too formal a mechanism to be totally effective. The new 12-member tribunal was not to be exclusively a lawyers' body. There were 3 lay representatives, and the quorum of 3 had to include at least 1 lay member. Rising community consciousness had created a wariness of experts and closed shops. In Parliament, Solicitor and future Premier Wayne Goss said, "The lay observer should reassure the public of the integrity of disciplinary procedures and the regulation of the profession generally." On the other side of the House, a barrister, Angus Innes, looked to the future. It seems to be the way of our times to move from total self-regulation to the intrusion of community participation. And the lay observer could attend meetings of council, the Complaints Committee and the Statutory Committee, and could make recommendations to the Attorney-General. Ironically, in view of earlier Labor government's displeasure with the profession, Wayne Goss, in speaking, said that the legislation will benefit the whole community, both directly and indirectly. He also thought that the Law Society's share of the readjusted diversion of interest on trust accounts should be more. However, it wasn't. But he couldn't resist remarking, "I'm always curious about why, on the government side, the so-called advocates of free enterprise and deregulation seem to be so obsessed with control and regulation in practice." The 1985 bill linked a minimal level of continuing legal education to eligibility for practicing certificates. The emphasis was changing from regulation of poor practice to prevention, from self-regulation of the profession to solicitors' own self-regulation. The 1985 changes to the disciplinary landscape were only the beginning. In 1997, further amendments abolished both the Statutory Committee and the first Solicitors Disciplinary Tribunal to create the Solicitors Complaints Tribunal. The Queensland Government was not standing still. The discussion paper on legal reform was published in 1998 and a green paper in 1999. This came at a bad time for the Society. Huge defalcations in the 1990s had imperilled the Fidelity Fund, and its balance of $512,000 could not address $10.4 million in claims. Urgent legislation was necessary. The government said it did not propose to abolish the fund and just wanted to ensure its future viability. The Attorney-General, however, warned that reforms of the fund would be part of the government's reform of the whole profession. The Legal Profession Act 2004 settled the structure of the fund and the complaints process. The Legal Practitioners Fidelity Guarantee Fund remained vested in the Society and administered by its Committee of Management. Retaining powers against possible government takeover became a theme for the new century. In 2002, the Courier Mail published allegations that the Society ignored complaints. In response to a highly critical review by the Legal Ombudsman and the Society's own review, the Society revamped its procedures at Law Society House and appointed a retired Chief Judge of the District Court, Pat Shanahan, to chair the Professional Standards Department. The Legal Profession Act 2004 changed the legal landscape forever. It was not only a matter of highlighting deficiencies in QLS procedures, it was, as the Attorney-General expressed it, the first stage of the government's reforms of the Queensland legal profession, a sea change for legal consumers. These reforms will raise professional standards, give consumers much more comfort, and establish a complaints system Queenslanders can trust. As the first state response to model laws generated by the Standing Committee of Attorneys General, the 2004 Queensland Act was part of a national movement towards uniform conditions for legal practice. It did remove the Law Society's power to investigate complaints and impose discipline. The Act introduced a new government officer, the Legal Services Commissioner, Queensland barristers were included in the regulatory system for the first time. There was a departure from the model laws. Instead of one regulatory body, Queensland retained two, the Legal Practice Committee and the Solicitors' Complaints Tribunal. The new regulatory regime recognised modern concerns. Alcohol abuse or depression could be taken into account, and this was another aspect of an emphasis on prevention. The admissions board could order a health assessment, and the society could suspend or cancel a practising certificate before malpractice occurred. Health assessments could not be taken into account in disciplinary procedures and were kept private to support a practitioner seeking help. There were opportunities for the society in exercising its practising certificate powers, enhancing education and caring for practitioner welfare. In 2007, the opposition sang an old tune in Parliament. The legal profession over the past 10 to 15 years has indeed suffered from what can be termed, at the very least, some very bad publicity. Solicitors who worked in legal aid or in community legal services were spared from this rebuke. It is these people that I believe need to be accoladed in our society more so than the larger firms. But the general thrust of the 2007 Legal Practitioners Bill was consumer protection and set the parameters within which solicitors had to operate. Justice Alan Wilson wrote that the 2007 Act promoted and enforced professional standards, confidence and honesty within the profession. To the judge, honesty really connotes frankness and openness. Community standards had become more overt. In the judge's view, not paying tax would indicate that failure as a citizen should mean that a person should not practice law. In 2004, the first Legal Services Commissioner, John Britton, stated his belief that professional bodies should have no role in monitoring or enforcing professional standards or deal with trust accounts. In his 2007-2008 report, the Commissioner noted that complaints against practitioners were falling from 1 in 4 lawyers earlier to 1 in 7 lawyers, which he said was a clear sign that the community is less dissatisfied and has more confidence in the profession. So, in coming to a close, how has the modern law society responded to these challenges, changes and opportunities? In the area of regulation, which is where this lecture really began, the legislative basis is now broadly outside the society. However, the Society's role under the 2007 Act in investigating matters which might lead to the suspension or cancellation of practising certificates is considerable and reflects an increased focus on prevention, requiring that principals of law firms complete a practice management course and the existence of the Ethics and Practice Centre are significant aspects of prevention and education. The Fidelity Guarantee Fund continues as the Legal Practitioners Fidelity Guarantee Fund, and the Society has now a power to intervene and practice when client property is at risk. However, in the language of a review of the New Zealand Law Society, released in March this year, professional bodies which retain any element of regulation are now outliers. Section 703 of the 2007 Act, enabling an injunction to be sought against anyone engaging in unlicensed practice, is a direct connection to one of the dominant pressures the 1873 Society sought to address. There were once calls from members for the Society to cease reinforcing the old order of dominance by large metropolitan firms. The current 12-member council, 8 women and 4 men, indicates that this issue has well and truly been addressed. The current President, Chloe Kopilovich, her immediate predecessor, Cara Thompson, and several female presidents in recent times are a visible expression of enormous change from 1986, when Elizabeth Nosworthy became the first woman president. A range of subcommittees and a much larger staff, some of whom helped me greatly with information, and I'm very grateful to them, has grown enormously. 15 members in 1873 has ballooned into more than 13,000, a majority of whom are women. The headquarters in Ann Street has endured much longer than its original 20 years. The 2023 renovations reflect the modern society, a large area where members from the country or the suburbs can work when they're in the central business district, plans for a coffee shop where ideas and grizzles can be exchanged, a beautiful new council room paying attention to the society's history and its name, the Beryl Donkin Room, and the naming of Nita Lee Way recognises that Beryl Donkin's record for long service may yet be exceeded and shows that the society has not overlooked its long-standing staff. In concluding, I can't help remembering advice from one of the best lecturers I have ever heard, the late Professor Geoffrey Bolton. Professor Bolton told me when I had to, for him, deliver a very, very, very boring lecture to first-year students, told me that a good lecture should have a crisp beginning, an informative body and a satisfying end. It is immensely satisfying that although this lecture must end, the resilient Queensland Law Society, with its proven ability to innovate and adapt, will continue with inevitable bumps along the road to serve conscientious, honest lawyers and those who aspire to be so.
Now, I've learnt from nearly 30 years in the legal profession that it would not be well received to make lengthy remarks which stand between the profession and refreshments, so I will be brief. First, I want to thank both of tonight's speakers for their thought-provoking presentations, and we have a small thank you for Ms Gregory.
Thank you very much.
Join with me in thanking them both. Secondly, it appears that the Queensland Law Society remains strong and in accordance with many of its original purposes. Thankfully, we can leave with our reputations intact and in safe hands for the future. Lastly, the tradition of the Selden lectures is a valuable part of the history of the legal profession in Queensland. It is wonderful that so many are in attendance in person and also online. I would like to thank everyone for their continued support of the Selden lectures and invite you outside to the Portrait Gallery for refreshments. Thank you.